Hello everyone, and welcome back to the channel. I am Mr. Kelly, your immigration analyst. If you are a green card holder, this is the most important video you will watch this month. April 2026 has brought some of the biggest immigration wins for permanent residents in years. But these wins come with a deadline. If you do not act now, you could miss opportunities that may not come around again for a very long time. At the same time, there are new rules in 2026 that are taking rights away from green card holders, rights that existed for decades. From losing access to business loans, to new biometric tracking at every airport, to new risks when you travel internationally, the landscape for permanent residents has fundamentally changed. In this video, I am going to cover every single thing a green card holder needs to know in April 2026. The wins, the risks, the deadlines, and the exact action steps you need to take. Stay with me until the very end, because I will also explain why some green card holders should seriously consider applying for citizenship right now. Let us get into it. Let me start with the biggest win first. The April 2026 Visa Bulletin has made the F2A category current. If you are a green card holder, and you have been waiting to bring your spouse or your unmarried children under 21 to the United States, this is your moment. F2A stands for the Second Preference Family-Based category. It covers spouses and minor children of lawful permanent residents. For years, this category had a backlog, which meant that even after you filed the petition for your spouse, they had to wait months or years before they could file for their green card. But in the April 2026 Visa Bulletin, F2A is listed as current in the dates for filing chart. That means there is no wait. If you have already filed a Form I-130 petition for your spouse and it is pending or approved, your spouse can now file Form I-485, the Adjustment of Status application, immediately. They do not have to wait for a priority date to become current because it already is. And here is something even more important. If you have not yet filed the I-130 for your spouse, you can now file the I-130 and the I-485 at the same time. This is called concurrent filing. It means your spouse can apply for their green card, their work permit on Form I-765, and their advance parole travel document on Form I-131, all at the same time, in one single package. Think about what this means. Your spouse could receive work authorization within a few months instead of waiting years. They could get a travel document that allows them to leave and re-enter the United States. And their green card application would be actively processing. This is a window of opportunity. F2A has not always been current. It was backlogged for much of 2023 and 2024. If the Visa Bulletin retrogresses in a future month, meaning the dates move backward, this opportunity disappears and your spouse goes back to waiting. My strong advice is this. If you are a green card holder with a spouse who needs a green card, file now. Do not wait until next month. Do not wait to see what happens. Prepare your I-130, I-485, I-765, I-131, and I-693 medical exam, and file them together as soon as possible. And remember the new I-485 rule. Starting in 2026, your medical exam on Form I-693 must be included in the initial filing. You cannot submit it later. So schedule your appointment with a USCIS designated civil surgeon right now, complete the exam, and have the sealed I-693 ready before you file. Also, USCIS now requires separate fee payments for each form filed concurrently. Now the second big win. The April 2026 Visa Bulletin also shows major advancement in employment-based green card categories. If you are a green card holder, this may not directly affect you, but it absolutely affects people you know, your friends, your co-workers, your community members who are waiting for their own green cards. EB2 is now current for all countries except India and China. EB3 is now current for rest of world and Mexico. EB2 India has advanced 10 months to July 15, 2014. USCIS is using the more favorable dates for filing chart for all employment-based categories. If you know someone who has been waiting for their employment-based green card, tell them to check the Visa Bulletin today. Share this video with them. This information could change their life. Now the third win, and this one is specifically for green card holders who are eligible for citizenship. The naturalization process in April 2026 is actually one of the faster immigration processes right now. Form N-400, the application for naturalization, is currently being processed in approximately 5.5 to 10 months, depending on your local USCIS field office. Some offices, particularly in smaller cities, are completing cases in under 3 months. Larger offices like Los Angeles and New York may take 10 to 14 months, but even that is significantly faster than many other immigration applications. Why does this matter? Because becoming a U.S. citizen gives you protections that a green card does not. A citizen cannot be deported. A citizen can vote. A citizen can sponsor family members in higher priority categories with shorter wait times. A citizen is eligible for SBA business loans, which green card holders are now banned from. A citizen does not have to worry about losing status due to extended travel abroad. Given everything that is happening in 2026, if you are eligible for citizenship, I strongly encourage you to apply now. You are eligible if you have held your green card for at least 5 years, or 3 years if you obtained your green card through marriage to a U.S. citizen. You can file your N-400 up to 90 days before you meet the residency requirement, so if you are within that window, you can start the process today. Now let me turn to the risks and the rule changes that are affecting green card holders negatively in 2026. The first negative change. Starting March 1, 2026, the Small Business Administration banned green card holders from SBA-backed business loans. This is not a small change. This is massive. Under the new rule, only businesses that are 100% owned by U.S. citizens or U.S. nationals living in the United States are eligible for SBA guaranteed loans, including 7A loans and 504 loans. Even if a green card holder owns just 1% of the business, the entire business is disqualified from SBA financing. In fiscal year 2025 alone, the SBA approved 3,358 loans for small businesses that were owned in part by lawful permanent residents. All of those businesses would now be ineligible. This rule was published by the SBA on February 2, 2026, citing Executive Order 12159, titled, Protecting the American People Against Invasion. Legal challenges have already been filed, but as of today, the rule is in effect. If you are a green card holder who owns a business or is thinking about starting one, you need to understand that SBA financing is no longer an option for you. You will need to explore alternative financing through private lenders, community development financial institutions, or other sources. And if you are eligible for citizenship, this is another strong reason to apply for naturalization as soon as possible. The second negative change. Starting December 26, 2025, CBP, which is Customs and Border Protection, began collecting facial biometric data from all non-citizens entering and departing the United States. This includes green card holders. Under the final rule published by DHS, CBP is authorized to photograph all non-citizens at airports, land ports, seaports, and other authorized departure points. This biometric data is used for identity verification and is part of the entry-exit tracking system. What this means for green card holders is that every time you travel internationally, your face is being scanned and recorded when you leave the country and when you return. The government now has a precise record of every departure and entry, including how long you were outside the United States. This matters because one of the biggest risks for green card holders is the abandonment of residency. If you spend too much time outside the United States, CBP can determine that you have abandoned your permanent resident status. Generally, any trip longer than 6 months raises questions, and any absence longer than 1 year without a re-entry permit can result in your green card being deemed abandoned. With the new biometric entry-exit system, CBP now has automatic, real-time data on exactly how long every green card holder has been outside the country. There are already reports in 2026 of green card holders being pulled aside at airports, questioned about their travel patterns, and in some cases, encouraged to sign forms that would result in abandoning their status. My advice is clear. If you are a green card holder, be very careful about international travel right now. Keep your trips under 6 months. If you must be abroad for longer, apply for a re-entry permit on Form I-131 before you leave. Never sign any form at the airport without first consulting an immigration attorney. And always carry proof of your ties to the United States, including tax returns, lease agreements, bank statements, and employment letters. The third negative change. There are reports that CBP officers and ICE agents are treating green card holders more aggressively at ports of entry in 2026. The National Immigration Law Center has documented cases where green card holders were detained at airports and encouraged to sign I-407 forms, which is the form you sign to voluntarily abandon your permanent resident status. If a CBP officer ever asks you to sign an I-407 form, do not sign it. You have the right to refuse. You have the right to request to speak with an attorney. Signing that form means you are giving up your green card voluntarily, and it is extremely difficult to undo once signed. Green card holders have the right to a hearing before an immigration judge before they can be deported. Unlike undocumented immigrants or visitors on temporary visas, you cannot simply be turned away at the border. You have due process rights. But those rights only protect you if you exercise them. If you sign the I-407, you have waived those rights. The fourth change that affects green card holders. DHS issued a memorandum on February 18, 2026, that changes how refugees are processed for green card status. Under the new policy, refugees who have been in the United States for 1 year are required to report back to the government for a case review as part of the adjustment to permanent residence process. If a refugee does not appear, DHS says it can arrest and detain them for the duration of the review. This is a significant departure from previous policy. Under earlier rules dating back to 2010, simply failing to complete the green card process was not considered a reason to detain a refugee. The new memo formally cancels those protections. If you are a refugee who has been in the United States for approximately 1 year and you have not yet filed for your green card through the refugee adjustment process, contact an immigration attorney immediately. It is critical that you file your I-485 and complete this process before DHS takes enforcement action. Now the fifth change. USCIS has expanded its screening and vetting procedures for immigration applicants. On March 30, 2026, USCIS announced that it has been placing holds on immigration cases from certain countries while conducting enhanced background checks. Some of these holds have been in place for months. USCIS also announced that it has now established a process for lifting holds for applicants from non-high-risk countries who have cleared enhanced vetting. However, cases from countries classified as high-risk may remain on hold indefinitely. If your green card application or your family member's application has been stuck with no updates for months, this could be the reason. Check with your attorney to find out if your case has been placed on hold and whether the March 30 announcement affects you. Now let me talk about the green card renewal situation, because this is something every green card holder eventually deals with. As of April 2026, Form I-90, which is the green card renewal and replacement form, is taking approximately 8 to 12 months to process. Some applicants are reporting wait times of up to 11 months for a 10-year card renewal. This is a dramatic increase from previous years when renewals took about 4 months. The filing fee for I-90 is currently $455. Once you file, USCIS will extend your green card validity for 24 months automatically. You will receive a receipt notice, Form I-797C, that serves as proof of your extended status. You can use this receipt along with your expired green card as evidence that your status is valid while you wait for the new card. My advice is to file your I-90 at least 6 months before your green card expires. Given the current processing times, you do not want to be in a situation where your card has expired and you have no receipt notice to show employers airlines, or government agencies. Now here are your 8 action steps for April 2026. Number 1. If you are a green card holder with a spouse or unmarried child under 21 who needs a green card, file Form I-130 and Form I-485 concurrently right now. The F2A category is current. This window may not last. Include Form I-765 for work authorization, Form I-131 for travel document, and Form I-693 medical exam in your initial filing package. Number 2. If your green card expires within the next 12 months, file Form I-90 immediately. Do not wait until the last month. With processing times of 8 to 12 months, you need to file early to avoid gaps. Number 3. If you have held your green card for 5 years, or 3 years if through marriage to a U.S. citizen, seriously consider filing Form N-400 for naturalization. Processing times are 5.5 to 10 months at most offices. Citizenship gives you protections that a green card does not, including protection from deportation, eligibility for SBA loans, and the ability to sponsor family in faster categories. Number 4. If you are a green card holder who owns or co-owns a business, understand that you are no longer eligible for SBA-backed loans as of March 1, 2026. Explore alternative financing options immediately, and consider naturalization to restore your eligibility. Number 5. Be extremely cautious about international travel. Keep trips under 6 months. Carry proof of U.S. ties. Apply for a re-entry permit if you must be abroad for longer. Never sign Form I-407 at the airport without consulting a lawyer first. Number 6. Review your social media accounts. If you are filing any immigration application or renewal, your social media may be screened. Make sure your profiles are consistent with your immigration records and do not contain anything that could be misinterpreted. Number 7. Check the USCIS case status online tool regularly. Enter your receipt number, turn on email and SMS alerts, and monitor your case weekly. If your case is beyond normal processing time, submit an e-request on the USCIS website or call 1-800-375-5283. Number 8. Consult an experienced immigration attorney, especially if you are affected by case holds, travel concerns, the SBA loan ban, the refugee adjustment changes, or any other issue discussed in this video. Professional guidance can prevent costly mistakes. Before we close, here are the key numbers from today's video. F2A is current in the April 2026 Visa Bulletin. Green card holders can sponsor spouses and children with no wait time right now. EB2 and EB3 Rest of World are current, first time in years. N-400 naturalization is processing in 5.5 to 10 months, one of the fastest USCIS processes right now. I-90 green card renewal is taking 8 to 12 months. File early. SBA loans are banned for green card holders as of March 1, 2026. 100% U.S. citizen ownership required. Biometric entry-exit tracking is now active at all ports of entry. Every departure and re-entry is recorded. March 30, 2026 is when USCIS began lifting case holds for non-high-risk countries. USCIS contact center number is 1-800-375-5283. The bottom line for green card holders in April 2026 is this. There are real tangible wins on the table right now. F2A is current, naturalization is fast, employment-based categories are moving forward, but there are also real risks. Your business loan eligibility has been taken away. Your travel is being tracked more closely than ever. Your rights at the border are being tested, and processing delays mean you need to plan further ahead than ever before. The green card holders who will come out ahead in this environment are the ones who act quickly, stay informed, and do not let deadlines pass them by. I will continue covering every development that affects green card holders and all immigrants on this channel every single week. If you found this video helpful, hit the like button right now. It helps this video reach more green card holders who need this information. Subscribe to the channel if you have not already, and tap the bell icon for notifications. Drop a comment below and tell me your situation. Are you planning to sponsor your spouse under F2A? Are you thinking about applying for citizenship? Were you affected by the SBA loan ban? Are you worried about traveling internationally? Let me know in the comments. I read every single one, and I will do my best to answer your questions. Share this video with every green card holder you know. The people in your family, your community, your workplace, they need this information. One share could make a real difference in someone's life. I am Mr. Kelly, your immigration analyst. Thank you for watching, and I will see you in the next video. Take care.